Can you believe this? Sometimes it's not good to be rich. I just posted a $91 million bond, 91 million, on a fake story, totally made up story. Think of it, 91 million. I could say things about what it would cost normally. 91 million. Based on false accusations made about me by a woman that I knew nothing about, didn't know, never heard of. I know nothing about her. She wrote a book, she said things. And when I denied it, I said, it's so crazy, it's false. I got sued for defamation.
It's a bunch of malarkey.
It's more than malarkey. So this idea is a bunch of malarkey, what we're talking about here.
An economy based on wind. I never understood wind. You know, I know windmills very much. I've studied it better than anybody. I know it's very expensive. They're made in China and Germany mostly. Very few made here, almost none. But they're manufactured tremendous, if you're into this, tremendous fumes, gases are spewing into the atmosphere. You know, we have a world, right? So the world is tiny compared to the universe. So tremendous amount of fumes and everything. You talk about the carbon footprint. Fumes are spewing into the air, right? Spewing. Whether it's in China, Germany, it's going into the air. It's our air, their air, everything, right? So they make these things, and then they put them up. And if you own a house within vision of some of these monsters, your house is worth 50% of the price. They're noisy. They kill the birds. You want to see a bird graveyard? You just go. Take a look. A bird graveyard? Go under a windmill someday. You'll see more birds than you've ever seen ever in your life. You know, in California, they were killing the bald eagle. If you shoot a bald eagle, they want to put you in jail for 10 years. A windmill will kill many bald eagles. It's true. And you know what? After a certain number, they make you turn the windmill off. That's true, by the way. They make you turn it off. And yet, if you killed one, they put you in jail. That's okay. But why is it okay for these windmills to destroy the bird population? And that's what they're doing.
It's a bunch of malarkey.
Two nights ago, we all heard Crooked Joe's angry, dark, hate-filled rant of a State of the Union address. Didn't it bring us together? Remember, he said, I'm going to bring the country together. I'm going to bring it together. Shades of color. They're like sort of white, but one's like an orange white. It's my favorite color, orange.
A bunch of malarkey.
I don't even wait. And when you're a star, they let you do it. You can do anything. Grab them by the you can do anything. That's what you said, correct?
Well, historically, that's true with stars.
It's true with stars that they can grab women by the
Well, that's what it's. If you look over the last million years, I guess that's been largely true. Not always, but largely true. Unfortunately or fortunately.
And you consider yourself to be a star?
I think you can say that, yeah.
very simple.
What are we going to do here, folks? I only need 11,000 votes. Fellas, I need 11,000 votes. Give me a break. Why do you keep fighting this thing? It just doesn't make sense.
We have to stand by our numbers. We believe our numbers are right.
What are we going to do here, folks? I only need 11,000 votes. Fellas.
It's a bunch of malarkey.
It's more than malarkey, man. It's more than malarkey. So this idea is a bunch of malarkey, what we're talking about here.
Ladies and gentlemen, the political gamer.
What up, everybody? Happy Friday. What up, what up, what up? How is everyone doing today? Happy Friday to you all. Hopefully, all of y'all who have been working throughout the week have a fantastic, restful, and laid-back weekend. For those of y'all that have had a fantastic, restful, and laid-back week, get to fucking work. All right, guys. So we got a little bit of a combined night tonight. I really wanted to game, but I wanted to listen to this Supreme Court hearing that happened. I believe it was this week. And let's see here. This was posted. So the January 6th argument should have been this week. Yeah. April 16th. So yeah, it happened this week. It happened 3 days ago. So I really want to, I've been working too much. I need to figure out what day it is. I know it's Friday, but that's pretty much it. So I really wanted to listen to the oral arguments here by the Supreme Court. So I wanted to be able to game as well. So I thought, why don't we marry the two, right? For those of you that are new to the channel, thank you so much for coming in. And for those of y'all that are always coming back to the channel, thank you so much for everything. We've had huge success this week with some of our TikToks. Hopefully, TikTok does sell from its parent company and we're able to continue at TikTok. But if not, I think we're going to push forward with YouTube either way. Yeah, thank you so much to all the follows for those of y'all that have been following on X or Twitter, and for those of y'all that have been following on TikTok. And we're still at 50 subscribers on YouTube, so thank you so much to all the YouTube subscribers. And we are 225 followers on Twitch, so thank you so much for those follows from Twitch. With that being said, we're going to go ahead and start the audio here. Just check everything before we get into the game. We're doing Heroes 2 Gold tonight, which if you were a returner of the channel or if this is your first time, it's a game that we played a couple of weeks ago. I used to play it as a kid all the time. It was a fantastic game. I don't know why I waited so long to acquire this game again, but it is a fantastic game. We already have a game going, so we're going to continue with it. So here we go. Let's see if we get some audio. And, it's from YouTube, so we're going to have some ads and whatnot. But for those of y'all that are unaware of kind of how the oral arguments for the Supreme Courts work, you basically... There's no video of any of this. They don't record any of that. What up, Homeless Bag? Thank you so much, my dude, for coming in. What's good? I mean, we're doing the Supreme Court arguments for January 6th charges. That was earlier this week. It was Tuesday, April 16th. And that's what we're going to be listening to while we do a little bit of gaming here. Y'all get to listen to my boring ass talk is what we're doing. Welcome in, though, Homeless Bag. So for those of y'all that have never listened to a Supreme Court hearing before, they don't televise the hearing, but they do allow the audio, and the audio was, I think, first radioed out in the 1940s or 50s. So really interesting, because those court cases have so this is like when Roe v. Wade was struck down, right? Like this is a monumentous thing. Now, of course, there is Roe v. Wade that has been struck down. There's nothing we can do about it except start clawing our way back to that point as a nation. But as far as this case goes, this is an unprecedented case. I was talking to Tater Salad earlier in Discord, and he said he was tired of hearing the term unprecedented, and I have to tell you, I am too. But these are unprecedented times. Homeless bag, I mean, I'm sure you're aware this is an unprecedented time. That's got to be something that you're experiencing along with all of us as well. But this is a Supreme Court hearing, the oral arguments from Tuesday, April 16th, 2024, and this is on the January 6th, 2021 Capitol building, Washington attack. And this is regarding some of the people that are currently being tried, that are currently convicted and serving time, if they should even be guilty of the crimes that they said have been committed. I haven't heard this. I've heard the commentary about this, some of the decisions. I don't even know how they were leaning on anything. So I'm really interested to hear this. We have a 5-2 or a 6-3 split on the courts. We have a 6 conservative majority and a 3 liberal minority on the court. But yet again, judges are supposed to be impartial, and I think that sometimes that does shine, right? Like sometimes we do get some court cases where judges are clearly right down the middle, and there are some topics, that's the whole point of the Supreme Court. There's topics that are really political. There's topics that are also not. Just fun fact before the audio starts here, just testing everything out. Unprecedented, how sick I am of hearing the word unprecedented. It's unprecedented. I mean, it's unprecedented how sick I am at hearing the term unprecedented. And to be honest with you, I'm just baffled, because it is an emotion that I never thought I would be. You could also say that it's an unprecedented emotion. But the Supreme Court also is supposed to be hearing the discussion of or arguments for homelessness. Homeless bag. This is part of your name. The homelessness that is here in America, and I think it's out of somewhere in Oregon is where the law comes from. But the idea is, can states fine people for being homeless, not having a home? And not to get too into it, because we could probably do a discussion on it, with our regular podcast that we do here, on Wednesdays normally. Whenever we go through and do that, we could obviously go through and talk about that. But ultimately, I believe it boils down to the arguments are going to be presented to the Supreme Court that in favor of the cities is that, there's crime, drugs, everything that's rampant. Notebook Dude is coming in with a sub for 8 months. Thank you so much, Notebook Dude, for coming in. Educate my dude. Thank you so much, man. Yeah, so I'm pretty excited to listen to the Supreme Court hearing on this, but going to and Notebook Dude, just stick around, man. I got a shout out coming for you. I just need to get through this update for you. So we end up having the Supreme Court argument that is going to be over homelessness, and it is the fact that in favor of ticketing, the state is saying that there is danger that comes from drug use, that comes from the homeless that are living around. They provide crime and things like that. It's also obviously not appealing to the site. And it doesn't help them get a move on with their life if they are being coddled by the state to allow to live under a bridge, if you will. With that being said, the argument for the idea of homelessness, which I think really is just like, it's America, right? Like, you don't have to have a home, but I mean, I digress. You know, I'll tell you, I do get uncomfortable living in Houston and seeing tent cities in downtown Houston, but at the same time, like, what do you want people to do, right? Like, we don't have the right to force them to do something. My personal opinion. But we're going to hear what the court has to say and how they respond here when that argument happens. I believe it's next week. So the argument for the homeless population and anyone who just wants to camp outside, because that's what they call it, right? They don't call it, you know, you're homeless. They say that it's outdoor camping without a permit, you know, is what they're saying. So the argument for that is that, you know, you can't force people to have fines and to pay fines and be ticketed, which, you know, incurs debt and, you know, things of that nature. It violates their, let me remember this, I believe it's 8th Amendment right to be able to withstand cruel and unusual punishment. And I believe that's what the argument boils down to. It is a pretty good argument because you shouldn't be able to force fines on people that are not clearly enacting and breaking laws. And the thing is there's no laws on homelessness. How do you define homelessness, right? And at least for the homelessness side, the argument is that there are not enough beds in the homeless shelters of the cities that are producing the fines in Oregon. And because of that, therefore, what do you want to do? Because even if you took every person who was homeless, you put them in that area, in that homeless shelter, and you don't have beds anymore, well, there's people that are going to be forced to sleep out on the street that would want to be in the shelter, but where are you going to find them? Because there's not enough room in the shelter. So that's the argument. That's the hinge that they're on, and it's a really good hinge and a really good argument. It is not appealing to the eyes to see 10 cities, but yet again, you know what? There's plenty of people that are wearing clothes that they really shouldn't be wearing at Walmart, and, you know, I just got to view it. So, you know, I'm all for making sure that the homeless have a place and a right in the United States to be able to camp freely in the world. I do wish there's something federally we could do for them. I wish there was programs. I wish there was things. That's coming next week. Either way, we're going to get to the argument today. The argument today is going to be the discussion of January 6 charges, and this is going to be with the Supreme Court. If you haven't heard one of these before, it's a fantastic listen. This one is, let's see, it appears to be an hour and 55 minutes long. We're going to be doing probably an hour and a half stream, maybe obviously probably like a 2-hour stream, right? We're going to be playing some games and whatnot. So there we go. Notebook Dude, don't shout me out. I'm here supporting you. Thanks, man. No, I always do shout outs for my fellow gamers that come in and support, man. Shout out to Notebook Dude. Homeless Bag, thank you so much. Let's go ahead and do that shout out right now. So at Notebook Dude, there you go, my guy. It always happens. Thank you so much. Boom. All right. There you go, guys. And for those of y'all that...
In case 235572, Fisher versus United States. Mr. Green?
Mr. Chief Justice.
There we go. Here it comes.
Congress enacted 1512C in 2002.
All right.
In the wake of the large...
Let's get into this game, too. I'm going to have to play with audio as we get started, but we'll get moving.
The statute, therefore, prohibits the impairment of the integrity or availability of information and evidence to be used in a proceeding. In 2002, Congress hedged a little bit and added Section C2 to cover other forms of impairment, the known unknowns, so to speak. It was, after all, the dawn of the information age. Until the January 6th prosecutions, Section 1512C2, the otherwise provision, had never been used to prosecute anything other than evidence tampering. And that was for good reason. This court has said that otherwise, when used in the criminal statute, means to do similar conduct in a different way. The government would have you ignore all that or disregard all that and instead convert C2 from a catch-all provision into a dragnet. One of the things that dragnet would cover is Section C1. Our construction of the statute at least leaves C1 and C2 to do some independent work.
I don't think we're going to need the game audio too much. I'll put it down pretty low for you guys.
Demonstrate that there are a host of felony and misdemeanor crimes that cover.
Get my phone for chat here.
A Sarbanes-Oxley-based, Enron-driven evidence tampering statute is not one of them. I welcome the court's questions.
Mr. Green, how do we determine what these two provisions have in common?
Let me see.
Do we look after the otherwise or before, and why?
You look at before, Justice Thomas, and you look at the kinds of manner in which documents and records are to be impaired, and then you look after to see what the effect is. But I would submit that the effect is the same, right, in order to cause the impairment.
That audio for the oral argument is as much as I can get, Notebook Dude.
Or to prevent its availability. So we look back and we look forward.
Wouldn't it be just as easy to look at the C2 and then ask what it has in common with C1 and use C2's provisions as a basis for that similarity?
No, because in C2 speaks to the effect of the actions that the otherwise clause covers. So in other words, we look at C1 and we see that Congress is concerned about documents and records and other objects and things that are done to those to impair the integrity of those. And the effect of that is to obstruct. And so C2 omits that object and verb section.
But you could just as easily say that Congress is really concerned about things that obstruct, influence, or impede official proceedings. And that's C2. So,
all right, cool. Thanks, Notebook.
The basis for the similarity.
Well, because of the presence of the otherwise provision. So otherwise, as I mentioned, and otherwise, this court has said, means to do similar conduct in a different way. So what we've got here is the impairment of evidence being done in a different way.
I'm sorry. I thought was, yes, doing it in a different way. So let me give you an example. There is a sign on the theater. You will be kicked out of the theater if you photograph or record the actors or otherwise disrupt the performance. If you start yelling, I think no one would question that you can be expected to be kicked out under this policy.
You have to give me a couple minutes here. I got to remember what we're doing.
It has nothing to do with photograph or recording. The object that the verb is looking at, the verbs are looking at, is the obstruction. It's not the manner in which you obstruct, it's the fact that you've obstructed. Isn't that the structure of this provision?
It is, Your Honor. It's in part the structure of the provision, but what your hypothetical omits is that there is a specific retriculation, I guess it's called, of all of the different sorts of things that might be done to evidence to begin with.
Except that what's fascinating about one, which is not about two, is that one doesn't require you to have actually impeded the proceeding. One requires you to have that intent, but you don't actually have to accomplish the intent. Two requires you to accomplish.
Pull it down just a bit more.
And so that's a very different articulation of what the object of two is. The object of two is the actual disruption of the proceeding.
Well, I would respectfully disagree because...
Well, why? Look at the language. Yeah. Alters, destroys, mutilates, or conceals a record. I do that in my home. And I do it anticipating that it might be needed. All I have to do is have the intent to impair. By that very language, I don't have to have an actual proceeding that I've impaired. On two, you need an actual proceeding to impair.
I guess
Let's see where everyone's going.
I'm a little confused, Justice Sotomayor, because as I read this, I would think that the government would say that any attempt at one is also covered by the statute.
Oh, we got
this.
That
I would disagree.
We're red, right? I think we're red.
There has to be an actual
no problem
impairment.
No, I do think under 1, you don't need an actual impairment. Under 2, you do.
Well,
if you read it, the
but
verb
2 says
requires you to actually obstruct the proceeding in 2. Nowhere in 1 do you actually have to obstruct.
Well, in 2, you only have to attempt to do the things that are in 2.
No, otherwise obstructs or impedes or attempts.
Taking on my bird.
Yes.
Counsel, can I ask you whether, let's imagine that we agree with you. On remand, do you agree that the government could take a shot at proving that...
What up, Tater? Thanks for the lurk, my guy.
...interfere with, or under C1, or actually, no, sorry, under C2, obstruct evidence because he was trying to obstruct the arrival of the certificates arriving to the vice president's desk for counting?
Got the audio.
Evidence impairment theory?
For the
I'm
argument.
quite sure that my friend would take a shot, Your Honor, but I would say no. And the reason why is that this statute...
Thanks for letting me know, but I'm trying to focus on the argument. This is the Supreme Court argument for January 6th that happened this week.
In some way, shape, or form. Attempting to stop a vote count or something like that is a very different act than actually changing a document or altering a document or creating a fake new document.
Well, he's obstructing evidence in my hypothetical. I mean, he's not actually altering the vote certificates, which is why I corrected myself and said under C2. I mean, would that be different than someone, say, in a trial or criminal proceeding trying to prevent evidence that was going to be introduced in the proceeding from making it there? So I'm imagining him acting on the certificates, not the act of counting them.
Dang, here goes my archer.
I try it, but I
cool.
don't think that we're talking about trying to impair just anything other than the evidence itself. We're trying to obstruct a proceeding. And there's questions about
He's going straight for the archer.
As Your Honor doubtless knows. But what the government would essentially be doing, as you noted, is
collision. Thank you so much for coming in.
To a C1 type of crime.
Well, no. C2. I mean, maybe I'm misunderstanding your argument, but I thought your argument was that C2 picks up other things, but they just have to be evidence related. So in the hypothetical I'm giving you, it's evidence related because it's focused on the certificates, but it's obstruct.
Yeah, it is, right? Like, it is a little bit weird, but I mean, the interesting thing about that is this is how the founding fathers, initially wanted this done. At least to a certain extent, I think I have to agree with you. Some of these arguments are so petty, right? Like, why are we going through and having these big arguments? Like, millions of dollars go into these, and it's over like a sentence. You know what I mean? Like, I know it's really weird, but it is part of what we're doing.
Prohibiting the kinds of impairments that actually change documents that actually affect their integrity. If it's just impeding or delaying, we'd submit actually that is not part of 1512C. Delays are mentioned in 5 other parts of 1512, but not in C.
Mr. Green, if Justice Barrett is wrong, then what work is C2 doing? I mean, it seems like you've just now re-articulated only the theory of C1, and you're saying that you have to make it into C1 in order to be, to have this statute apply. So can you help me at least understand, under your theory, what additional thing does C2 offer?
Let's look at the verbs of C1, which are alter, destroy.
Circle jerks? The UN is a circle jerk. Let me tell you, the UN is a circle jerk.
Instead of destroy would be actually to create. So one could use some sophisticated computer program. We've heard an awful lot about AI.
Having the 3 sections of government and the other 2 sections, the legislative, the executive can move around a bit. Having
the photograph that established your alibi,
the backbone of the Supreme Court, that's kind of like an unchanging and unwavering arrow, is a good deal.
So you're saying
it's kind of like England with the constitutional monarchy.
Particularly altering, destroying, mutilating, or concealing, but it has to be limited to a record?
Not necessarily, because, one other example, if I might, Your Honor, would be not to conceal, but to disclose. So if I disclosed a witness list in a large multi-defendant drug trial, my purpose in doing that, though I haven't altered the document, would be
92.
to intimidate the witnesses or prevent their attendance. That, on our submission, would also violate C2.
All right, can I just ask you one other question just so that I can fully understand your
Maybe
theory?
I'm
You
not
keep
going to win
using the
this.
term
92.
evidence, and that does not appear in the statute. The statute C1 says record, document, or other object. Now, I appreciate that, you know, evidence can be such a thing, but you can imagine a world in which those two are different. So where does evidence come in your theory, and why is it there?
Well, the title of the statute refers to tampering with witnesses, victims, and informants. But along with witnesses, victims, and informants comes evidence that they provide, whether in the form of testimony or whether in the form of documents.
No, I understand, but the statute, the provision we're talking about here, does not use the term evidence. And so, and instead, or in addition, it uses the term official proceeding, which is elsewhere defined, not in terms of, you know, court proceedings or investigations. It's just a proceeding, you know, before Congress. So is it your argument that the only thing that this provision covers is something that is tantamount to evidence in an investigation or trial?
It is, Your Honor, and we're not limiting it. Our position does not limit it to documents or records. I would submit C1, which we say carries into C2 through the otherwise clause, when it says other object, is pretty broad. And it need not be as 1512F provides. It need not be admissible.
We're going to get gangbanged here.
It need not be admissible. So it could cover.
Don't worry, we're Stormy Daniels. We can take it.
It could cover communications. It could cover emails. It could cover all kinds of things that we think get used by fact finders in a formally convened hearing.
I mean, just to take you back to
just a quick question.
Oh my God, are you kidding me?
Decision in U.S. versus Reich, where what was involved was not evidence; it was a forged court order. Would that fall within C2?
Yes, we think that does fall within C2.
Dude, I swear I saw.
I think anything that is falsified in this
Oh my goodness!
way
Wow. Okay.
that is used to obstruct a proceeding would be covered by C2.
Thank you.
Yes.
And just to take you back to the question that Justice Thomas started you with, I mean, it seems to me there are two choices here, and you could read this as otherwise obstructs a proceeding or otherwise spoils evidence. And you're using it to say otherwise spoils evidence with, you know, spoils being all those verbs. But it doesn't say that. It says otherwise obstructs a proceeding. There are plenty of ways to write the statute that you want to write. You could just say otherwise affects the integrity or availability of evidence in an official proceeding. You could combine official proceeding with evidence in other ways. You know, one with, you could replicate the mens rea that C1 has. I mean, there are ways in which C2, multiple ways in which the drafters of C2 could have made it clear that they intended C2 to also operate only in the sphere of evidence spoliation. But it doesn't do that. All it says is otherwise obstructs, influences, or impedes.
Certainly the statute could be written more precisely. Any statute could be written more precisely.
Well, it's not a question of precisely. The question is, what is this otherwise? This is what Justice Thomas said at the beginning. What is this otherwise taking from C1? Of course there's commonality that's involved in an otherwise. There's both commonality and difference. But what is the commonality that C2 is drawing from C1? It tells you what the commonality is. The commonality is that the things that fall into C2 also have to obstruct, influence, or impede. But what C2 does not say, really does not say, is everything in C2 also has to spoil evidence.
But this court has said that otherwise in a criminal statute means similar conduct.
Similar conduct, obstruction of
This game notes is Heroes 2 Gold. It's available by Ubisoft.
Which is obstruction
It
of a
is a fantastic old school RPG game. There's several of them. I believe there's 5 of these overall, but it's a really neat game. You can get it on Ubisoft, and believe it or not, it's like $3 now, like $3.
And so a drafter of the statute could easily omit something like that and would omit something like that for the sake of economy and also to hedge, because we know that what comes before might not be exactly the same as after. So we're not going to repeat what we said there, but we're going to use a connector like otherwise to demonstrate that we're talking about similar conduct. And I would submit, Your Honor, that if you look at C2 alone, that is, please.
What's your best case for this, like, going backward? And
If y'all have never listened to one of these court hearings before, the oral arguments, there's a lot of like back and forth. So it's hard to really understand who's whom. You just have to kind of listen to the point and kind of infer who it is, because we don't get a picture. Like I'm on YouTube right now. This is the actual oral argument put out by the AP, and there's no video. There's never video for the Supreme Court justices.
Did not use in the otherwise provision, and we derive various things from it, and we put it in. It was purposeful, violent, and aggressive. And then a few years later, we said, where did that come from? We made it up, and we...
It is slightly zoomed in. It is playing on DOSBox.
So that's not a great advertisement for rewriting a statute to take an otherwise provision that says what it says and turn it into an otherwise provision.
There's not too much I can do notes about it. I can go through and like just pull out, and I can have like it in the middle of the screen, have a border around it, which I think I'll do for the next time. It is bothersome. I would agree with you. It is not perfection here, but it's DOSBox that's running in the background to be able to run this game. So you have to download a version of DOS whenever you get this game, which it automatically will do for you. But yeah, it's an old game. It's from like 94, 95, maybe Windows 95.
To another person might be looking at what came before. That doesn't.
I'm sorry, Mr. Green. Go ahead and finish your sentence.
Yeah, but that doesn't mean that the court's holding about how to construe a statute and its significant holding about otherwise was abrogated in and of itself as a result of the cases that came after Begay.
Well, I'm not a fan of Begay. Some of us perceived at that time that there were different problems with what the court did there. But I think there's a point in the colloquy that
this guy might need to go here.
Specific types of conduct that are enumerated in 1, alter, destroy, mutilate, conceal a record, document, etc., have two things in common. 1, they all involve documents or objects, and they also all involve the impairment of the object's integrity or availability for use in an official proceeding. So the similarity could be either of those things. And so I think that you may be biting off more than you can chew by suggesting,
we got
if
3
you
of
are
them.
indeed suggesting that the otherwise clause can only be read the way you read it. One might say it can certainly be read the way the government reads it, and that might even be the more straightforward reading. But it is also
Can't take him out
possible
right
to
now.
read a clause like this
The Hydra's potentially.
more narrowly.
I
And
do have
Judge
2
Katz has
dragons,
provided an
but
example
no.
of that in his opinion. If you had a statute that says anyone who kills or injures or assaults someone or otherwise causes serious injury, commits a crime, you wouldn't think that that applies to defamation. So it could be read your way. So then I think you have
Let's
to
just
go
see
on
where
to
we're at. I
some
mean,
other
we're in late
arguments and
game, so we're
explain
going to be
why
fine.
Your reading is better than
Number of heroes, so they've got really good heroes. Let's see if we can buy a hero. We should have bought our hero back.
There are plenty of other reasons why our reading is the better reason. And I'm not going to contest or bite up more than I can chew and say that the government's reading of C2 is implausible. We think it's unsound, but it's unsound for the additional reasons that if one zooms out and looks at what the prohibited conduct is in 1512 generally, we are talking about interference or operation on forms of evidence and testimony that obstruct a proceeding. That's what 12 is all about generally. I would submit, Your Honor, too, that as the briefing indicates, Jus Gem Generis and Nocitur Socius, those two venerated Latin canons, also operate in our favor here, as well as the broader context of Chapter 73 and Section 15. All of these things are about doing things that obstruct a proceeding. 1512 and 1512C zero in on witnesses and evidence.
Well, you have other arguments. You have
This is a strong build.
arguments.
We'll run them around.
You have arguments about the breadth of the government's reading of the provision. Do you want to say anything about those?
Right. So with respect to surplusage, Your Honor, I would refer to Judge Katz's opinion, as you did, in particular in the joint appendix at page 88, which lists out all of the different provisions in Section 1512. 15 of the 21
I like this
would
chick
be
a lot.
subsumed by the government's reading of C2. The government's reading of C2, I remind the court, is so broad that it would cover anyone who does something understanding that what they're doing is wrong in some way, that in any way influences, impedes, or obstructs an official proceeding of any type.
Well, Mr. Green, I
maybe
think that
limited by federal.
There's a good
There's
case
some
for
OP
this provision.
right here. This guy's OP.
Everybody knew it was going to be superfluous because it was a provision that was meant to function as a backstop. It was a later enacted provision. Congress had all these statutes all over the place. It had just gone through Enron. What Enron convinced them of was that there were gaps in these statutes, and they tried to fill the gaps. They tried to fill the particular gap that they found out about in Enron, and then they said, you know, this is a lesson to us. There are probably other gaps in this statute. But they didn't know exactly what those gaps were. So they said,
this guy's a
let's
peon,
have
so we got to watch
backstop
out. He's
provision. And
all
this
this
is their
person has
backstop
is just
provision.
random
And of
stuff
course,
that
in that circumstance,
is not really mattering.
Superfluity is very often a good argument when it comes to statutory interpretation.
This person
but it's
would
not
be
a good
owned.
argument when Congress is specifically devising a backstop provision
I think we're
to
talking
fill
about
gaps
centaurs.
that might exist. They don't exactly know how they exist, but they think that they probably do exist in a pre-existing statutory scheme. And that's what this provision is intended to do.
Respectfully, Your Honor, a close reading of Yates, both the majority opinion and the dissenting opinion, demonstrates that this court thought that 1519 was the backstop. That was supposed to be the omnibus provision. And the court was fighting over what the meaning of tangible object was in 1519. But that was meant to plug the hole.
Counsel,
that Congress...
I have such a hard time with the superfluidity argument because this entire obstruction section is superfluidity. There isn't one provision you can point to. You just said it. You can point to 1512 and you have 1519, which says destruction of evidence. How are they different? They're really not. You can point to any series of any provision and point to superfluidity in this section, 1512 and otherwise. So we go back to Justice Kagan's position, which is what you don't have is a freestanding, otherwise obstructs, influence, or impedes any official proceeding. I don't see why that's not the backstop that Congress would have intended, and it's the language it used.
Okay. Well, it's an awfully odd place to put it, isn't it? I mean, in a subsection of a subsection in the middle back of the statute to include a provision that suddenly takes over
there's
15
nothing
of the
about
21 other provisions.
The one thing that Justice Kagan pointed to, which is clear, they wanted to cover every base. And they didn't do it in a logical way. But they managed to cover every base.
Well, I think you can reconcile. I mean, again, that's what the court said about 1519 in Yates. And I don't understand how it is that the government can come before you today and say we need yet another catch-all, yet another omnibus crime that will sweep in all kinds of other. We didn't get what we wanted in Section 15, so now we'll go to 1512C2 and see if we can expand that in this way to cover something that it has never covered before.
Thank you, Counsel. Justice Thomas, Justice Alito, Justice Sotomayor.
We've never had a situation before where there's been a situation like this with people attempting to stop a
Mofo, you gonna come all the way down there?
So I'm not sure what a lack of history proves.
Well, I'm not sure that that's true. I'd point to the Hatfield courthouse problems in Portland, Oregon, but let's also look at what the court has said in so many different cases in Dubin, in Bond, in Yates, in Kelly. All of these cases.
But there was a difference in the use of words. Here, otherwise obstructs, influences, or impede. You might have a problem with breadth, and the government can address that. But it's not unclear what those words mean.
But the government has no way to address its problem with breadth.
Well, we can let them answer.
Okay.
Justice Kagan? Justice Kavanaugh?
If it were just the language in C2 and so said, whoever corruptly obstructs, influences, or impedes, C2 without the word otherwise, that were the whole provision, do you acknowledge that the language would then be applied properly to a situation like this?
Damn it.
Unfortunately, no. And the reason for that is that, again, applying all the other canons and applying the whole text canon and zooming out and looking at 1512, we would submit that C2 should still be read in the way we have suggested that it be read, as something that is an evidence impairment statute. I think also, as I mentioned, the Latin canons, the surplusage problem that C2 would create, all of those would still obtain if it sat there by itself without the otherwise. The otherwise is the icing on the cake. And finally, Justice Kavanaugh, I would mention that, as I mentioned to Justice Barrett, there's an issue.
If you didn't have C1, just had C2 without the otherwise, I'm not sure I was clear on that.
Oh, okay. Well, in that case, I think it gets even harder, but I would still say if we look at what 1512 is about, and if we look at this court's cases on plausible but broad readings of criminal statutes.
So this character has to get
when there's an available
oh, you're fucked. This character has to get a castle because they don't really have much going on.
Perform the massive dragnet function that the government submits.
Thank you.
416, clearly.
I have a question about the phrase in C1, the specific intent. Do you agree it's specific intent with the intent to impair the object's integrity? Okay.
Let's have some fun.
What is your view about how that parenthetical applies to C2, if at all? Like, do you think that intent requirement carries over?
The corruptly intent requirement?
Not corruptly. With the intent to impair the object's integrity or availability for use in an official proceeding.
Yes, we do, Your Honor.
So it carries over.
And we say that's the opposite.
She fucked him up.
Of the overarching mens rea.
But
That's
how
crazy.
Can that be?
I don't know if I've ever seen that.
You know, C2 would read awfully oddly then. It would be otherwise obstructs, influences, or impedes any official proceeding with the intent to impair the object's integrity or availability for use in an official proceeding. That would be your position of how it would
Damn,
be.
that was a waste.
Well, I think that's right.
Get this fucker
it's awkward.
around.
I mean, there's no doubt that it's an awkward statute. But if you do the operation that I talked about earlier, which is we're just going to use otherwise to replace the verbs and the nouns in C1, then the statute makes perfect sense. With respect to intent, I mean, I think Your Honor makes an excellent point, which is that this intent is a specific form of intent.
This was supposed to be a lot easier.
Construed to be the mens rea up there is not different than, at least on this reading,
fuck up both.
Is not or on the accepted reading it by the D.C. Circuit right now, is not different than some form of specific intent.
So corrupt.
198. Wow.
It seems like it's getting to be. Yes.
Okay.
That's true. And our submission is that corruptly should mean something different. So should proceeding. That's how you marry 1512 with 1519.
Justice Jackson.
So I'm just still wondering if your theory about this provision might be too narrow in a sense.
Why are they coming with less power? What's happening with my boy here?
My mind is whether you would still have a decent argument if this 1512 language
Thank God.
Is read to prohibit the corrupt tampering with things
Fuck
that
them
are
up.
used to conduct an official proceeding with the intent of undermining the integrity of the thing or access to the thing, and thereby obstructing the proceeding. It's not just evidence.
That's truly remarkable.
C1 is an example of, the corrupt tampering with certain things, and C2 broadens it out a bit. It's not just documents and records. What do you think about that?
Well, I think that's correct reading, Your Honor. I mean,
what is happening? What the fuck?
As 1512F demonstrates, it doesn't, 1512F we would submit actually supports our position because it says the evidence need not be admissible or free of a privilege claim. Now, what would that mean about what
literally
the statute
lost
is
so
addressing
much.
if it's not evidence? But
These sprites.
C2 has been applied, and occasionally C1 has been applied.
In a non-evidentiary way.
Yeah, to things that could become evidence.
Yeah, run back,
the
bitches.
Efforts to shape someone's grand jury testimony.
All right,
answers to interrogatories.
Let me ask you about the question that Justice Barrett asked before. You suggested that it has to be to the document, but in other words, the activity has to be actually to the document.
This game came out roughly 1993, 1992, somewhere in there. Pac-Man, it is an old game. It is, by the way, welcome in, Pac. But it is Heroes 2 Gold.
Justice Barrett posits a scenario in which you have
it's a turn-based strategic game.
Impairing the availability by doing something to prevent the object from getting to the proceeding. Why wouldn't that count under C2?
Let's go ahead and get that.
This is, preventing Congress from counting the electoral votes, for example. Let's say it's being done. She says it's in an envelope going to the vice president's desk, and someone does something to impair or prevent that from happening. Why isn't that what C2 could cover?
Well, first, it's not affecting the integrity of the document, Your Honor, or the
availability is also in the statute.
Availability, it says too, but as I mentioned earlier, simply delaying the arrival of evidence at the courthouse.
No, not delay. Let's say the person steals the envelope and takes it away.
Then it gets harder. I agree. They steal the envelopes, they take it away, they rip up all of those things, which is certainly not what happened here, and it's not in the indictment. The ballots or the vote count is not even in the indictment.
But we wouldn't have to decide that. We could send it back if we clarified that is what the statute
peasants,
means.
or I think we're going for peasants here.
Agree that that's what the statute could mean?
No, I don't agree that that's what the statute.
Why not?
The reason is that if you look at 1512, it is about a direct effect, or in some senses an indirect effect, but in a limited way, on evidence that's to be used in a proceeding, right? And proceeding, as I mentioned earlier.
So as to limit its availability. So what I'm suggesting is in C2, if you're doing something to limit limit its availability, why doesn't it count?
Because we're limiting the availability of its use by a fact finder in a proceeding. Again, that's the way to marry 1519, which covers all kinds of investigations and all kinds of other events, with 1512. 1512 is talking about evidence that's going to a formal convocation, some kind of hearing before the Congress or before any other body.
Thank you.
Thank you.
Thank you, counsel.
Thank you.
I'll have to load her up. I'll have to get people going on this.
General Prelogger.
Mr. Chief Justice, and may it please the court.
So, Pac, this is January 6th, so this is affects Trump, but this is also about the other people who are on trial because of January 6th or who are currently serving time.
Wrong committed by many of the rioters, including petitioner, was a deliberate attempt to stop the joint session of Congress from certifying the results of the election. That is, they obstructed Congress's work in that official proceeding.
Let's get back to the original castles and see what's going on. We haven't been here in a minute.
1512C2, an obstruction offense that directly reads onto his conduct. The case as it comes to this court presents a straightforward question of statutory interpretation. Did petitioner obstruct, influence, or impede the joint session of Congress? The answer is equally straightforward. Yes, he obstructed that official proceeding. The terms of the statute unambiguously encompass his conduct. Petitioner doesn't really argue that his actions fall outside the plain meaning of what it is to obstruct. Instead, he asks this court to impose an
we're gonna fuck some shit up.
In his view, because Section 1512C1 covers tampering with documents and other physical evidence,
Tell you what.
the separate prohibition in Section 1512C2 should be limited to acts of evidence impairment. But that limit has no basis in the text or tools of construction. His reading hinges on the word otherwise, but that word means in a different manner, not in the same manner. And the true prohibitions in Section 1512C2 aren't unified items on a list where you could apply associated
We have
words
no money.
canons. They're separate provisions. They have their own sets of verbs and their own nouns. They each independently prohibit attempts, which would be duplication that makes no sense on petitioner's reading.
So,
and Congress included a distinct
Pac, it's important to remember that the trials that have been going on have been civil.
C2, by its terms, is not limited to evidence.
Those are civil trials.
Instead, it's a class
This week, we started the first criminal trial of a former president. So this is actual criminal. This case is the January 6th case, which is out of Washington, D.C. This case still has yet to be booked. The court system is very slow, and Donald Trump has been very proficient at utilizing appeals.
Has the government applied this provision to other protests in the past? And has this been the government's position throughout the lifespan of the statute?
It has certainly been the government's position since the enactment of 1512C2 that it covers the myriad forms of obstructing an official proceeding and that it's not limited to some kind of evidence impairment gloss.
Have you enforced it in that manner?
We have enforced it in a variety of prosecutions that don't focus on evidence tampering. Now, I can't give you an example of enforcing it in a situation where people have violently stormed a building in order to prevent an official proceeding, a specified one, from occurring with all of the elements like intent to obstruct, knowledge of the proceeding, having the corruptly mens rea, but that's just because I'm not aware of that circumstance ever happening prior to January 6th. But just to give you a flavor of some of the other circumstances where we have prosecuted under this provision, for example, there are situations where we've brought C2 charges because someone tipped off the subject of an investigation to the grand jury's hearings. There was another case where someone tipped off about the identity of an undercover law enforcement officer, and in those situations, there's no specific evidence, no concrete testimony or physical evidence that the conduct is interfering with. Instead, it's more general obstruction of the proceeding. Justice Alito mentioned the Wright case as well, and that's another one where it was a forged court order that prompted the litigant to dismiss a mandamus petition, but that didn't have anything to do with the evidence that was going to be considered in that proceeding.
So what role does C1 play in your analysis?
So we understand 1512C to split up the world of obstructive conduct of an official proceeding into the C1 offense and into C2. C1 covers everything it enumerates. It's the acts of altering, concealing, destroying records, documents, or other objects. And then C2 would only pick up conduct that obstructs an official proceeding in a different way. So there's no duplication or superfluity on our reading. Instead, Congress was taking this universe and dividing it up into the two separate offenses. And I think that's actually a virtue of our reading as compared to petitioners, because I have not heard him articulate anything that would fall within C1 that wouldn't also come within C2. So on his reading, C2 really does just swallow C1 whole.
Well, I mean, in the way you're reading it, C2 almost exists in isolation, certainly not affected by C1.
We don't deny at all that there is a relationship between the two provisions, Justice Thomas.
What is that relationship?
And the relationship is the one Congress specified in the text. It's what follows the word otherwise. That is the relevant degree of similarity. What both C1 and C2 have in common is that they or aim at conduct that obstructs an official proceeding. C1 does so in one way, tampering with records and documents. C2 does so with respect to all other conduct that in a different manner does that. And I think that this has to be the road the court goes down, to look at what Congress actually prescribed with respect to similarity. Because in contrast, if you take up petitioner's invitation to
I'm not going to worry about that. I need to
textual gloss from C1 to port over into C2, I don't understand what the court could look at to guide its determination of exactly what the relevant similarity would be.
General, I'm sure you've had a chance to read our opinion released Friday in the Boysonet case. It was unanimous. It was very short, but it explained how to apply the doctrine of justum generis. And what it said is that specific terms, a more general catch-all, if you will, term at the end, and it said that the general phrase is controlled and defined by reference to the terms that precede it. The otherwise phrase is more general, and the terms that precede it are alters, destroys, mutilates, and seals a record and document. And applying the doctrine as was set forth in that opinion, the specific terms alters, destroy, and mutilate carry forward into 2, and the terms record, document, or other object carry forward into 2 as well. And it seems to me that they, as I said, sort of control and defined the more general term.
So, Mr. Chief Justice, I think that the statute...
I'm sorry, just to interrupt so I put out exactly what... And the otherwise means in other ways. It alters, destroys, and mutilates record, document, or other objects that impede the investigation, and otherwise, in other ways, accomplishes the same result.
So I think the problem with that approach with respect to 1512 is that it doesn't look like the typical kind of statutory phrase that consists of a parallel list of nouns or a parallel list of verbs where the court has applied a justum generis or the Noskator canon. You know, these are separate prohibitions that have their own complex, non-parallel internal structure. And I think actually the best evidence that it's hard to figure out how you would define a degree of similarity between them just based on the word otherwise is that there are multiple competing interpretations at issue in this case. You know, Justice Alito touched on them, and they're reflected in the competing interpretations.
Yeah, criminal trials are better, to be honest.
And Judge Nichols on the
sentencing hearings are juicy. Yeah, they are. I don't like to watch them, though. I just prefer the jury.
Judge Nichols thought that C1 should limit C2, and he looked at it and said, well, the relevant thing about C1 is it deals with records, documents, and other objects.
He will still be able to run for president. So this is homeless bag. If you're still here, this is an unprecedented time. But yes, you can still run for president, unfortunately, which I find weird, right? Like, I didn't realize that. And I swear I learned that if you're convicted of a felony, then you can't run, but whatever. You still can.
And I think you do that as well. What are the common elements? Alters, destroy, and mutilate.
Delivering his inaugural speech from jail could be a fact. But I'll be honest with you, Pac, he's not going to win.
Both of those, as it said in Boisonette, controlling and defining the term that follows.
He might even get more orange.
Something that's capable of alteration, destruction, and mutilation, and with respect to a record or a document. That's how.
I actually don't even understand.
Got you on the car speakers in its glories now. Thanks, Tater. Hopefully everything went well with moving your parents' couch.
It responds to some of the concerns that have been raised about how broad C2 is. You can't just tack it on and say, look at it as if it's standing alone, because it's not.
So let me respond to that in 2 ways. I do want to have a chance to address any concerns about breadth, but the more fundamental point, I think, is that
that should be doing more damage because he's living and that's an undead.
And the nouns from C1 and C2 in this way. Judge Nichols had a more limited view that C2 exclusively focuses on physical objects. It wouldn't apply to things like testimony because of the limitation that he gleaned.
This fucking bird, man.
Judge Katsas, I think, may be in line with your question, would interpret it more broadly. And the basic point as a textual matter is that there is nothing in the text of C2 itself to disclose what the relevant similarity from C1 ought to be. Instead, we think the relevant similarity is obstruction of an official proceeding because that's the language Congress chose.
Well, if that's the case, what work does authorize do on your theory? Because I think I might, as I'm hearing you, think that whoever corruptly obstructs, influences, or impedes any official proceeding or attempts to do so stands alone. And the otherwise, I'm not hearing what work it does. Can you explain to me what work it does on your view?
Yes. So the work that otherwise does is to set up the relationship between C1 and C2 and make clear that C2 does not cover the conduct.
Kill this fucking bird.
Now, I acknowledge that there would have been...
Beyond that.
This bird is needing to be gangbanged bad.
Some things, and the whole rest of the universe of obstructing, impeding, or influencing is conducted by C2. Is that a fair summary of your view?
Yes, but there was a good reason for Congress to do it this way. It traces to the statutory history.
I understand
and
that.
I would just say that...
If I might. So what does that mean for the
God,
this statute?
Fucking damn it. Like, thank goodness.
That disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would
kill this guy.
A fire alarm before a vote qualify for 20 years in federal prison?
There are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512c2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means that if you have some minor disruption or delay or some minimal outburst, we don't think it falls within the actus reus to begin with.
My outbursts require the court to reconvene after the proceeding has been brought back into line, or
Let's get him.
Pulling of the fire alarm.
What up, bitch? I'm back.
Or the protest outside of a courthouse makes it inaccessible for a period of time. Are those all federal felonies subject to 20 years in prison?
So with some of them, it would be necessary to show nexus. So with respect to the protest outside the courthouse, we'd have to show that, yes, they were in that proceeding.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's
Let's
not
get
even
this
just
one.
the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
We went around that tree yesterday.
I know. I heard the argument yesterday, but I guess what I would say is that to the extent that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of those protesters had corrupt intent.
Protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Come on back this
We would
way.
just have to have the evidence of intent, and that's a high bar.
They intend to do it, all right.
Yes, if they intend to obstruct and we're able to show that they knew that was wrongful conduct with consciousness of wrongdoing, then yes, that's a 1512c2 offense. And
what does corruptly add, in your view?
So corruptly adds the requirement that the defendant's conduct be wrongful and committed with consciousness of wrongdoing. And this traces to the court's decision in Arthur Anderson, where the court said this is a term with deep historical roots, with a settled meaning, and that it connotes not just knowledge of your actions, which is, the intent to obstruct in this case, but further requires that it be done corruptly. And just to give you a more concrete example of how this has played out in the January 6 prosecutions, I'd point to the jury instruction in the Robertson case, which we refer to and quote in part on page 44 of our brief. There, the jury was instructed that in order to show the defendant acted corruptly, the jury had to conclude that he had an unlawful purpose or used unlawful means or both, and that he had consciousness of wrongdoing. So I think that is an encapsulation of what the jury is asked to decide.
This is one of their big heroes with all this loot.
General, let me give you a specific example, which provides a little bit more detail with respect to one of the examples that Justice Gorsuch provided. So we've had a number of protests in the courtroom. Let's say that today, while you're arguing or Mr. Green is arguing, 5 people get up, one after the other, and they shout either keep the January 6th insurrectionists in jail or free the January 6th patriots. And as a result of this, our police officers have to remove them forcibly from the courtroom. And let's say we have to it delays the proceeding for 5 minutes. And I know that experienced advocates like you and Mr. Green are not going to be flustered by that, but, in another case, an advocate might lose his or her train of thought and not provide the best argument. So would that be a violation of 1512c2?
I think it would be difficult for the government to prove that.
Why?
At the outset,
Dirt313, thank you so much for coming in.
Minor interference.
Thank you so much for coming in and saying what it do. Yeah, we're doing fine. We're playing a little bit of Heroes to Gold, and then we're listening to the January 6th Supreme Court case hearing that happened this week.
Influences or impedes. Impedes is something less than obstructs.
He's not able to rally enough people. Notes. I don't want to take too much away from what's happening here, but when you look at poll numbers, where you look where Biden has come from, and you look where Trump is trending, and also when you look at the polls for the Nikki Haley supporters, it's almost impossible for Trump to actually win. It's going to be a low turnout election, and that normally benefits Republicans, but not this time.
The OED, it is to retard in progress or action by putting obstacles in the way. So it
man.
require.
Thank you so much for the dehydration break, Tater.
Requires the causing of delay.
And if this
So
court...
again, why wouldn't that fall
There we go.
Now,
Thank you so much for the follow as well.
For all the protests
Jared 313.
Court, the Justice Department has not charged any serious offenses, and I don't think any one of those protesters has been sentenced to even 1 day in prison. But why isn't that a violation of 1512C2?
We read the actus reus more narrowly. Now, perhaps you could look at some of the broader dictionary definitions and adopt a broader understanding of the actus reus. Still, there would be the backstop of needing to prove corrupt intent. I think that's a stringent mens rea.
Well, that's
and
not
the
a
concept
corrupt
of
intent.
How come I cannot buy?
Do you think it's not wrongful?
I could imagine defendants in that scenario suggesting that they thought they had some protected free speech right to protest. They might say that they weren't conscious of the fact that they weren't allowed to make that kind of brief protest in the court. And I think it's in a fundamentally different posture than if they had stormed into this courtroom, overrun the Supreme Court police, required the justices and other participants to flee for their safety, and done so with clear evidence of intent to obstruct.
Now we're on them.
January 6th was very, very serious, and I'm not equating this with that. But we need to find out what are the outer reaches.
Teleporting to get out. Okay.
Interpretation. Let me give you another.
Yeah, take this one. I'm gonna just come get you.
Protesters blocked the Golden Gate Bridge in San Francisco and disrupted traffic in San Francisco.
What can I fuck up while I'm here?
To the Capitol, so that members, all the bridges from Virginia were blocked, and members from Virginia who needed to appear at a hearing couldn't get there or were delayed in getting there. Would that be a violation of this provision?
It sounds to me like that wouldn't satisfy the proceeding element nor the nexus requirement.
Why would it not satisfy the proceeding? Let's say they want to get to the Capitol to vote.
Well, if we had clear evidence that the purpose of the protesters who had set up the blockage somewhere, some distance away from the court, was because they had a specific proceeding in mind, maybe you have the proceeding, but still the court has required a nexus, and that's been the requirement in cases like Marinello, Aguilar, and Arthur Anderson, where the court has said it does real narrowing work, because you have to show that the natural and probable effect of the action is to obstruct. There has to be a relationship in time, causation, and logic. But Justice Alito, the other thing I would say to this set of concerns is that there are other obstruction provisions, including in 1503, 1505, the tax obstruction statute 7212, that use this exact same formulation that the court has characterized as an omnibus clause and never suggested could be subject to an evidence gloss. So I don't think that to the extent you have concerns about those hypotheticals, your question
always blinding
would be covered by 1503, and interpreting this statute narrowly isn't going to cure that issue.
Let me give you one more example. An attorney
Let's go and take out this bitch.
Sanctioned under Rule 11 of the Federal Rules of Civil Procedure by filing pleadings, written motions, or other papers for the purpose of causing unnecessary delay or needlessly increasing the cost of litigation. And in a particular case, the judge imposes Rule 11 sanctions and says, this caused a lot of trouble. I can tell you it caused at least 5.
You know, Dirt, a lot of people don't like Joe Biden. The problem is that a lot of people also don't like Trump and what he stood for, what he did. We can talk about economics, but it's just a fact when you look at everything. Economics takes anywhere from 3 to 5 years to actually trickle down. That's why Biden right now is getting positive vibes running through the economy, and Trump has never had a good economy, and the economy at the beginning of his term was inherited from Obama. Democrats tend to have better economies than Republicans. Republicans tend to give more tax breaks, especially to the rich, and that's what people see more, is they see these massive tax breaks. But I mean, not many people like Joe Biden. I'll be honest with you, I actually like Joe Biden. I think Joe Biden's doing a pretty decent job at, you know, being president of the United States.
With respect to using unlawful means with consciousness of wrongdoing, we have focused on things like
weird shit does happen, Notes. It does.
Violence, willingness to use violence here. We allege that petitioner assaulted a police officer. We have focused on things like preparation for violence, bringing bringing tactical gear or paramilitary equipment to the Capitol.
The problem notes is Gen Z and millennials are two different groups. Gen Zs are actually starting to favor Trump.
150 defendants with crimes committed on January 6th.
Millennials favor Joe
Only
Biden,
had the evidence of intent to bring
especially when you talk about black and Latino males. Gen Zs and millennials, they really like Trump.
Charged under this
Biden has lost ground with that category of the electorate.
Hinged usually on the evidence we have of intent. So we're looking for clear evidence that the defendant knew about the proceedings that were happening in the joint session in Congress that day, clear knowledge of the official proceeding. We've looked for evidence that the defendant specifically intended to prevent Congress from certifying the vote, and so used his actions to obstruct that proceeding. And then also, as I'd mentioned, the knowledge of wrongfulness or unlawful conduct can come about with
Notes, yeah, I mean, it is a little bit unfair, but, you know, it is a repeat of 2020. But I feel like, you know, the main argument, yet again, not trying to take too much away from here, but the main argument is going to be like, when you look at the polls, when we look at everything, when we dissect things doing our normal stream, like, I feel really confident that Biden is already won.
To sustain these convictions, and it's because of the stringent mens rea.
General, can I ask you about your obstruction theory?
Black Gen Z is what you're referring to. So the black males in the United States that are part of Gen Z are very into Trump, and they're also black males that are in millennials are into Trump. Not that they are majority Trump, but they had a Democratic stronghold, or Democrats had a stronghold with the black male population, and unfortunately that is moved away and towards Trump because he speaks his mind and he kind of lives really boldly, and it's something that the black men of America really enjoy. At least that's what polls are telling us. Yet again, it's, you know, polls are polls. You know, they're not facts.
I don't think that's true. There is certainly overlap or duplication. That's true on both of the readings in this case. I think in part it might even be more true on petitioner's reading, because he says that C2 is likewise focused on all of the evidence impairment ways to obstruct.
It is an interesting comment though, Pac. It is very interesting.
So that very same
notes, I mean, you know, like, yeah, I mean, Colorado, different. Colorado is normally a blue state anyway. But still,
because each of those other provisions that you cited, and in fact, each of the other provisions of the obstruction laws cover situations that 1512C2 wouldn't cover. There are three principal distinctions. The first is that some of them have
I didn't know that, Pac. That's really neat.
So for many of the provisions, they can be violated in ways that wouldn't require the government to prove corruptly, and it might mean that we could charge particular applications of those provisions under them and not under C2. The second thing is that some of the provisions sweep more broadly than an official proceeding. They apply in a wider range of circumstances.
I mean, they don't have the largest impact, right? But when you start looking at the fact that, you know, you have the fight in Gaza right now with Israel, Gen Z and millennials are needed to secure the White House for Biden. And unfortunately, when you talk about Latinos and black males specifically,
the government necessarily,
it is a landslide that has moved away from Biden. Whether they want to not support him and not support Trump, or they want to support Trump, any vote that doesn't go to Biden is in effect, right? So,
but related to conduct that prevents or obstructs an official proceeding insofar as it is directed to preventing access to information or documents or records or things that the official proceeding would use.
There is a third-party candidate that is pulling a lot of the young black male vote. His name escapes me, but it's not Colin Allred. Colin Allred is a senatorial prospect here in Texas. Hopefully, outbeats Ted Cruz. But there is a
qualify under even an evidence or document.
He's a household name amongst the black community. So
yes, I think that if
I'm trying to remember his name. I'll figure it out and get back with you.
And as we noted note in the last footnote of our brief, we preserved an argument that we could satisfy even an evidence-related understanding of C2, in part because the very point of the conduct when we have the intent evidence was to prevent Congress from being able to count the votes, from being able to actually certify the results of the election. Now, we'd obviously need to evaluate whether these charges can go forward based on whatever this court says, and I would very much caution the court away from any holding that would require specific evidence by the government of, precise electoral certificates or that kind of thing. Here, the point of it would be that those who came to the Capitol and engaged in criminal conduct to displace Congress violently from where it had to be to count those votes acted with an intent to impair Congress's ability to consider that evidence.
General, the district court and the dissent below had a different variation on the statute and how to read it. You were starting to explain that to the chief. Could you do it if we accepted the district court's view? I presume that you could do it if we accepted the dissent below, correct?
Yes.
Yeah, so but your whole response to Justice Ketanji, to Justice Jackson, sorry.
That motherfucker came out of nowhere.
Jackson is that it assumes the dissent's view.
I thought that Justice Jackson was potentially proposing even a broader view, including focusing on the availability part and making clear that when the whole point is to prevent the proceeding, including the consideration of evidence in the proceeding from happening, that could qualify. Okay. I think it becomes potentially harder on the Judge Katz's view and especially harder on the Judge Nichols' view. And that's precisely because Judge Nichols seemed to think that to prove obstruction, it had to be limited to taking action with respect to the documents themselves. And that would be a difficult standard for us to
that was kind of useless. Okay.
Discussion on corruptly yesterday. It's clear you've endorsed the Robertson view. Could you tell me what you feel about the Walker view? Judge Walker being the part of the majority below. I assume you know that, but.
Yes. So Judge Walker articulated an idea that corruptly has to turn exclusively on the government being able to show that the defendant sought to secure an unlawful advantage for himself or someone else. We certainly agree that that's one way for the government to prove corrupt intent. It's a way that has traditionally been deployed in the tax context because the very theory of the case is that the defendant is violating the tax laws or taking efforts to secure an unlawful advantage under the tax laws. But I think that it would be incorrect for the court to suggest that that's the exclusive mechanism for the government to try to prove corruptly. There are various other ways where we might have evidence of, as we think we do here, unlawful means committed with consciousness of wrongdoing, and there's no basis in the common law or in how the term corruptly has long been understood to limit the government's ability to prove it only with that one specific way that Judge Walker pointed to.
The drawer in this case appears to be the fear that reading the government's view of either yesterday's case or today on its plain terms would make it so broad that somehow that presents a problem. I think the judges below struggled with that by saying that gets addressed in the word corruptly and in the nexus requirement, which is the point you've made today. But neither of those two issues were resolved below because that wasn't the question below, correct?
That's right. The only issue that the D.C. Circuit resolved was the meaning of the actus reus.
And the only issue between us is whether we read the words, how we read these words.
That's right. But I don't want to lose sight of the fact, as your question touched on, that there are inherent constraints built into the other elements of the statute. The nexus constraint is a really critical one. It is the paradigmatic constraint the court has pointed to ensure that obstruction statutes don't sweep too broadly and scoop up everyday conduct that might be happening out in the world. It has to have that tight connection, the relationship in time, causation, or logic with the official proceeding. And of course, corruptly, we think, sets a very high bar, as evidenced by the fact, as I said to Justice Kagan, it's not like we can even prove it with respect to everyone who was in the riot at the Capitol on January 6th.
Thank you.
General, are you putting a violence requirement as an overlay on obstruct, influence, impede? And I'm thinking of some of your answers to Justice Alito's hypotheticals. It seemed like you kept emphasizing the aspect of violence
Truly
that was
insane.
present on January 6th. So am I understanding you to say there has to be some sort of violence, or no?
No, we don't think that's a requirement under the statute. I think it will clearly be easier for us to satisfy things like the corruptly mens rea when we can point to action here, like assaulting a police officer that is obviously wrongful, unlawful conduct, and everyone knows that that's a crime and you cannot do that. What I was trying to say to Justice Alito is in situations where hypotheticals press on the idea that people are engaging in conduct that maybe they think is constitutionally protected, they might be wrong about that. There might not be a First Amendment right that they think they have, but that can demonstrate that they don't have the requisite consciousness of wrongdoing. That would mean we couldn't prove an obstruction charge.
Thank you, counsel. I'm not quite sure I understood the answer you gave earlier about whether or not you've previously used C2 in this type of case. Have you done that before or not?
We have charged
Pac, there's definitely a couple of active groups of young black men that are very into politics, that are very active and are trying to get people to vote. There's definitely also a opposition to that argument and saying that there's a group of young black men that are, supporting someone like Trump, that are very active and looking to get people to vote as well. But yeah, I mean, it's a pretty amazing.
And then we would also need to show an intent to obstruct the proceeding and the nexus to the proceeding, and that can take care of situations where maybe someone's pulling a fire alarm in a different building, but it's not even where the proceeding happens.
In prior cases, you have applied C2 in a situation, not involving specific documents?
Correct. So things like tipping off someone to the existence of a grand jury investigation, or the identity of an undercover officer, or creating a fake court order. That
all right, I don't want to see these fucking boys come back
to dismiss a pending mandamus petition.
And your friend points to an Office of Legal Counsel opinion from 2019 that I haven't looked at it yet.
Come on over. Get fucked.
It is consistent with Judge Katsas's opinion below.
So that advice that was offered to the Attorney General and never adopted as a formal position of the Department of Justice related to distinct issues that arose out of the special counsel investigation and distinct issues that involved the Office of the Presidency. I don't think that it would be right to suggest that the memo took any firm stand, although it did suggest that maybe 1512C2 should be understood more narrowly, but it certainly didn't represent any formal adoption of that position, and that would have been inconsistent with how the government has always litigated under C2.
What constitutes a formal acceptance of OLC?
There we go. Lost 3 Phoenixes, but
probably know the answer to that one as a matter of DOJ policy. But what I can tell you is the reason I'm saying that wasn't an official position is because it specifically said there's no need to go down the road of even deciding exactly what 1512C2 covers, because even assuming that it covers the full range of obstructive conduct, the allegations, according to the memo, didn't satisfy the standards there. So it ultimately just punted on the issue and said it's not necessary to engage with that issue further.
Thank you. Justice Thomas?
General, you said, as I understand it, that you have applied C2 in previous cases.
That's right. We've applied it in cases that do not fit the evidence impairment model that petitioner is urging on the court here. And it's not just C2, Justice Thomas, but it's the omnibus clauses of 1503,
no, I can't attack that yet.
7212. These are statutes that use the exact same verb
those
phrase.
Those are fine, but C2.
Yes.
I'm not clear as to whether or not the specific instances in which you have used C2, because you seem to think that argue that C2 is a standalone provision almost.
We think that it covers the full range of obstructive conduct that's not covered by C1, of course limited by the requirement of an official proceeding.
So if you have applied C2, have there been previous, other than the D.C. Circuit, previous courts of appeals that have looked at this?
Yes, and the uniform consensus among the Court of Appeals has been that C2 is not limited by this kind of evidence impairment gloss that petitioners asking the court to read into the statute. There has been no Court of Appeals that's gone the other way. We cite a string side of them that have
take out this fucking leech.
Looking at the plain language of this provision, that it sweeps in the myriad forms of obstructive conduct.
So much of your argument seems to hinge on this being fairly clear, your interpretation of C2.
Yes, we certainly think we have the best of the plain text.
Bitches!
We think if I happen to think it's more ambiguous, what would your argument be?
So what I would say is I think that if you look at the terms in the statute themselves, that the plain language of the statute supports our view, but it doesn't end there. And I have mentioned several times the other provisions in 1503, 1505, but we think that's actually really relevant because Congress wasn't writing on a blank slate when it enacted 1512c2. It's not like it just thought of for the first time this verb phrase obstructs, influences, or impedes. That wasn't taken out of the ether. That was a well-established term, verb phrase, and obstruction law drawn from those other statutes. And as this court has said many times, when Congress takes a phrase like that, it brings the old soil with it. And so Congress would have clearly known that the courts, this court and lower courts, had interpreted the omnibus clause in those other statutes to encompass the full range of obstructive conduct. That's also consistent with all precedent, as I mentioned to you earlier. So I think when you put it all together, there's no real ambiguity here. We clearly have the best reading. And the only other thing, the icing on the cake, if I could, is that if actually what Congress wanted to do is write a statute that focused only on evidence impairment, there was a really clear and obvious way to do it. Congress could have just tacked on a residual clause to C1 that says, or otherwise impairs evidence. It would not have used this
That was actually not a bad move.
Otherwise, and then used a term that had a well-settled meaning in obstruction law to sweep more broadly to try to convey that type of limited scope. It would just be nonsensical for Congress to draft that way.
Ooh, that might
it would
hurt.
be so readily misunderstood. And in fact, every lower court has understood Congress to have legislated.
How you have low morale, bitch?
That's beginning to sound more like a contextual argument.
Come on.
Which you seem to eschew in this case.
Well, no, I think
Perfect.
actually that the statutory context and history does bear weight here. And we think that the roots of this language and those other obstruction provisions help fortify or reinforce how the court has always understood the plain language.
Justice Alito?
You argue that there's an exception for conduct that has only a minimal effect on official proceedings. Where does that come from in the text?
That comes from the verb phrase obstruct, influence, or impede, which we think, if you look at dictionary definitions, conveys the type of action that blocks, hinders, makes difficult, persistently interferes with. This is the kind of, the verbs themselves we think inherently contain this limitation.
There can't be a minor impediment?
I think as a colloquial matter, yes, maybe, but we think that if you look at what Congress was trying to do as a whole, the lead term here is obstruct. These were various ways of trying to capture the world of obstructive conduct, and I think that adequately conveys the idea that some kind of very minimal de minimis.
Oh, why did I do that?
Well, it didn't stop with obstruct. It added impede. But what is the meaning of, how would you define a minimal interference? I suppose a jury would have to be charged on that. In order to prove that the person violated this provision, you must find that the person committed more than caused or intended to cause more than a minimal interference. How do you define it?
So I think, to the extent that this would come up in actual prosecutions, and I'm not aware of any, but if this came up, then I think that it would be the defense theory. It's possible that the court could decide it as a matter of law if, in fact, it was so minimal it doesn't fit within the statutory terms themselves. And I recognize that maybe there could be gray areas about the nature of the obstruction and whether it really satisfies the actus reus. I think that is properly a subject
what about
for
the
the jury.
example I gave you about the 5 protesters in the courtroom? Is that minimal?
I think that sounds minimal to me. I mean, it sounds to me like if it hasn't actually forced any substantial halt to these proceedings, it seems like that wouldn't pick up and track. But, the same issue would arise under 1503, which likewise refers to obstruct, influence, or impede.
Not
You
good.
haven't said anything about the surplusage arguments. Let me just ask you a question or two about that. Suppose someone
these fucking
commits
turrets.
conduct that falls squarely within
These turrets got me on this
1512D.
one.
The person intentionally harasses another person, and therefore
The morale indicator, there's not one here. It's when you go to your character. I'll show you when we get out.
you've got a clear violation of 1512D, punishable by no more than 3 years in prison. But when Congress added 1512C2, which seems to cover exactly that conduct, it said, well, the punishment shouldn't be, you could punish that person for up to 20 years.
There's a key difference between 1512D and 1512C.
So when you go here,
in that
you can
D
see where
doesn't
your
require
morale's
the
at.
intent to obstruct. And so the effect of the defendant's
Normally morale comes when you have like
or the production
a couple of
document,
different people
but
mixed
the government
together,
has not
you
read
have
that
morale
statute to
issues.
require an actual intent.
It's very weird how the dragons end up having low morale,
where the
but
government
it
might be able
happens.
to prove a 1512D offense without satisfying C2. But I do want to be responsive to the broader concern that there's something anomalous about the 20-year penalty here. Let me say at the outset that no matter which statute the government charged under, with respect to all of the relevant obstruction statutes here, they would be funneled through the same sentencing guideline. So the charging decision wouldn't make a difference with respect to the sentencing range. And the concern you have with the hypothetical arises equally on petitioner's reading, because so too, everything that would be covered in 1512D falls within his evidence impairment limitation. So I don't think the existence of a statutory max when there's no mandatory minimum should drive intuitions about how to interpret this provision.
Well, I'm not sure that's the correct interpretation of subsection D1. How about 1512B, which also has a 20-year penalty, but it seems to be completely subsumed by C2.
I think there is a lot of overlap between B and C. I don't deny that. Again, that would be true on either reading because B is paradigmatic witness tampering. And so even on petitioner's understanding of the statute, there would be equal duplication there. What I would say is there's no actual superfluity because there are ways of violating B that wouldn't fall within our understanding of C2, including acting in a misleading manner towards someone, which wouldn't necessarily satisfy a corrupt intent definition.
Let's get this guy moving.
Really, you think you could knowingly threaten or corruptly persuade, corruptly mislead someone? I don't understand that argument.
So my recollection is that there are multiple different means of carrying out that offense. Of course, something like threatening or corruptly persuading, that's the kind of duplication I was referring to earlier. But another way you can violate B is through intentionally misleading someone. That wouldn't necessarily require corrupt intent.
I'll be honest with y'all, it's a little bit rough going not only in the game here that I thought was going to be a piece of cake to win, but here in the trial, it seems like she's really got an uphill battle for the state.
Contrast between your argument here that the court should read in a minimal...
The dragons are normally really good, though. Titans are best.
Earlier this term in Muldrow versus the city of St. Louis, where the question was whether an adverse employment action has to be significant or not. And you said, no, it doesn't have to be significant because, quote, the text likewise admits of no distinction between discrimination that results in a significant or insignificant disadvantage. So in Muldrow, you told us, no, don't read in an atextual requirement of significance, but here you seem to be arguing, yes, you've got to read in an atextual requirement of something that's more than minimal.
No, that is not our argument here. We are grounding this in the text. So we're not suggesting that there's a basic de minimis principle that applies throughout all the various legal statutes that are out there, not anything like that. Instead, we ground this in a particular understanding of what it means to obstruct and what that word conveys.
Thank you.
Justice Sotomayor?
I know the Risch case because I decided it. However, the tip cases, are they in your briefs?
We cite Ahrensfeld. That's the case where a subject of a grand jury investigation was tipped off about the existence of the investigation, but there was no, kind of material impact or clear evidence of impairment of the evidence or availability.
Yeah, it really sounds like they're not going with her
and
case.
There are a number of cases in that line, including, I don't think we specifically cited, but it includes the disclosing the identity of an undercover officer.
Where do I find those?
We would be happy to supply additional citations if you're looking for them. I believe that the D.C. Circuit decision as well cited a range of C2 cases and made clear that they didn't cover evidence impairment.
Thank you.
Justice Kagan?
Mr. Green referred a few times to 1519 and basically said, well, that's supposed to be the catch-all provision, the omnibus provision. Why are you asking 1512 to do the same thing that 1519 is supposed to do? So that's one question I have for you. And the other question I have is just, you've referred a number of times to other omnibus.
This is a good angle right here. Watch.
1503, 1505.
Peace!
What's the tax one? 70
for one right there.
26 U.S.C. 7212.
If we go down Mr. Green's road in terms of importing other limits from other places in the statute, are any of those likely to be challenged in the same kind of way, or are they written sufficiently differently so that we wouldn't have to worry about that?
So let me take the questions in order. With respect to petitioner's reliance on 1519 as the catch-all here, I understood the court's decision in Yates to say precisely the opposite. In fact, Yates drew a direct comparison between 1519 on the one hand, which it said was a more narrow obstruction provision.
Right, so there's two running around. One's by their base, though. One's just randomly running around, so that's not too concerning.
Or other object, and said, well, that's the broad obstruction provision. That's the
take
one
this marble. They might come running back.
Prohibition that's aimed at official proceedings, and that C1 language is actually quite broader and would scoop up the entire world of physical objects, in contrast to the narrowing interpretation the court accepted in Yates. So I don't think the idea that 1519 was the broad catch-all can in any way be squared with what that statute says or how this court interpreted it in Yates. And instead, I think that the example to draw from Yates, or the lesson to learn from it, is that this court recognized that Congress was plugging the specific hole in the Enron scandal, and it did so with overlapping provisions, 1512C1 and 1519, but it was 1512 that the court pointed to.
Get these paladins or crusaders out.
Provision that aims at the full range of obstructive acts to catch the known unknowns. With respect to the question, I'm sorry, now I'm forgetting the second question, about the other statutes and whether they would be endangered. I would be concerned about that. I'm sure defendants would try to make arguments. The language, the verb phrase is exactly the same, or in different order sometimes, but it obstructs, influences, or impedes. And so
I think this is fine.
And the actus reus would be similar. There are different direct objects there. For example, in 1503, it's the due administration of justice.
My boy here's going to do way better.
It's the administration of the power of Congress's inquiry and investigation. But it's not clear to me whether defendants might seek to try to now artificially limit those clauses beyond their plain terms, even though these kinds of provisions have been in the obstruction law. I think it traces all the way back to 1830, and they've never been understood to have that kind of narrow limitation to evidence impairment or anything else.
Thank you. Ms. Gorsuch, Justice Kavanaugh?
I think the key word is otherwise, and trying to figure out what that means under our established principles of statutory interpretation. It would seem to trigger justum generis under the Begay.
I will not do that. Thank you so much for the recommendation notes. I will not be on Qbot show.
Scalia Garner book describes
as much as I would love a lot of extra follows. I'm doing great on TikTok. I actually really like TikTok. I like take a lot of my content here and move it to TikTok. I'm really working on YouTube as well. I'm trying to get my podcast going as well from my Wednesday streams and move that into Spotify podcasts. But I will not be on Qbot show just for marital reasons. Not gonna do it, bro. It's not worth it on my half.
But that's just not how 1512C is structured. It has, as I've mentioned, its own complex internal structure. You know, you've got the mens rea requirement that's unique to C1, and Congress did not transplant that into C2. That triggers the other canon.
See if I can get this guy to chase me down a little bit.
Provisions. Usually it means something by that. So I think that this just isn't the kind of situation where the court could sensibly apply justum generis. And the other thing I would say is that, you know, if the court goes down the road of trying to glean some kind of requirement from C1, the other reason the canon is inapplicable here is that it's not evident on its face what the common attribute would be, and that relates to the Nichols-Katsas dispute.
As you know, that's true in almost every justum generis case, and the treatise explains that as well, which is it's hard sometimes to figure out what the common link among the words in the phrase is. So that's, I don't think that point I don't think distinguishes this case from other justum generis cases, but you can respond to that.
But I do think that a plain
that's a nice little barrier right here.
That usually the common link or the connective tissue is the language that follows the word otherwise. That's the congressionally approved similarity. That's what C1 and C2 have in common. They both relate to obstructing an official proceeding.
Yeah, and, man. You know, I have my daughter's birthday on Sunday, and tomorrow we're cleaning and doing decorations, man. I am not going to mess with stuff. I'll tell you what I'll do is I will make a couple of comments about Qbot show to the wife, get her a little riled up, and then attack her later in the bedroom. That's what I'm going to do.
That it would be odd to have such a broad provision tucked in.
Oh shit, I should have gone for the fucking rocks, these birds.
I don't think
Let's
that
defend him.
The statute is odd at all for a couple of different reasons.
See, sometimes there's luck too.
I was trying to make to Justice Kagan about this court's own recognition that 1512 is one of the big obstruction statutes. This is the statute that is aimed generally at officials.
They're from the same type, so
other provisions like
the Titans should be much
and
better.
Some of the ones that come right before it that are more narrowly confined and are intended to reflect discrete circumstances. That doesn't describe 1512 at all. So when Congress was trying to broadly prohibit obstruction of official proceedings,
Dude, that dragon didn't take out these hobbits? What? Like, that was insane.
In the middle of the statute.
2 strikes for the hobbits, 225. That was amazing. Blind. I already have
I was
it.
discussing with Justice Alito has a much more minimal penalty and doesn't require the intent to obstruct. So it made sense to put 1512C before
Tell you what, we're gonna have 2. We're gonna confuse them.
Serious obstruction, like killing a witness, punishable by 30 years or up to life.
Last question. There's 6 other counts in the indictment here, which include civil disorder, physical contact with the victim, assault, entering and remaining in a restricted building, disorderly and disruptive conduct, disorderly conduct in the Capitol building. And why aren't those 6 counts good enough, just from the Justice Department's perspective, given that they don't have any of the hurdles?
Because those counts don't fully reflect the culpability of petitioner's conduct on January 6th. Those counts do not require that petitioner have acted corruptly to obstruct an official proceeding. And obviously, petitioner committed other crimes that we've charged and that we're seeking to hold him accountable for. But one of the distinct strands of harm, one of the root problems with petitioner's conduct is that he knew about that proceeding. He had said in advance of January 6th that he was prepared
Need
to
some of
storm the
these
Capitol,
dragons.
prepared to use violence. He wanted to intimidate Congress. He said they can't vote if they can't breathe. And then he went to the Capitol on January 6th with that intent in mind and took action, including assaulting a law enforcement officer that did impede the ability of the officers to regain control of the Capitol and let Congress finish its work in that session. And I think it is entirely appropriate for the government to seek to hold petitioner accountable for that conduct with that intent.
And are the sentences, the sentence available is longer for this count than for any of
So
the
we can
other
take out
counts, or
this
all
guy
of them?
before that.
The statutory maximum
Freaking
is higher, but after a recent decision in the D.C. Circuit,
Paladin
which
gets
held
over
that
here.
a particular sentencing enhancement doesn't apply, that was the Brock case. I believe the sentencing range, the guidelines range for the assault count would actually be a higher.
Those swordmen are going to be a problem down
Give you a
here.
sense for a typical January 6th defendant, someone who doesn't have a prior criminal history and who committed violent conduct at the Capitol, accepting responsibility. I think the average guidelines range or the range that would yield is 10 to 16 months of imprisonment. For someone who didn't commit violence, it would be 6 to 12 months of imprisonment. We've looked at the average sentences.
Swordmen are coming. Fuck.
50 that have gone to sentence,
Boom.
conviction and sentencing on just a 1512C2 is the only felony, so I think that's the best way to gauge it. This was when the sentencing enhancement did apply, so the ranges were higher. The average sentence among the approximately 50 people is 26 months of imprisonment, and the median has been 24 months. So there's no reasonable argument to be made that the statutory maximum here is driving anything with respect to sentencing.
Justice Barrett?
General, I want to ask a clarifying question about the distinction in the government's charging decisions between C1 and C2. Actually, let me make that stronger, not charging decisions, like what you could charge under the statute. So as you pointed out to Justice Kavanaugh just now, C1 has this additional mens rea requirement, but, there is overlap if you read otherwise obstructs, influences, etc. Broadly, it would encompass, frankly, even on the other reading, it would encompass things like alters,
How many magic, but he's got him. No problem. So y'all are doing that. Oh, he's taking him down quick. You're going down.
To Justice Jackson earlier in the argument that the government could not charge
They're from the same
alteration,
place.
mutilation,
What up, Devil? Thanks for coming in for the lurk.
document or physical object under C2. Am I?
That's correct. We usually charge the specific paragraph, and so if the conduct fits within C1, we would charge.
Yeah. So notes, man. When you're in like that kind of like.
And is that charging
environment, man, there's a lot of guys that are trying to be all alpha, which are like losers. They're like legit losers.
Well, let me say
and I'm just not gonna mess with that. But I do like to watch the show. My wife has watched the show with me.
To mutilate a document or something.
That also gets her riled up. It's fun stuff.
Proceeding. This is pressing on, honestly, what's a difficult question about means versus elements. And I think the best reading of the statute is that these are different elements because they have these different actus rea. They have the different mens rea requirement, the mens rea requirement that's specific to C1. They each independently prohibit attempts. But it's a hard question ultimately. And if we charged under the wrong paragraph accidentally, I think we could usually say that was harmless error. Or
Wizards go out like Jedi? Yeah, man.
Okay, let me ask you a question.
Really Qui-Gon Jinn.
Some of the same points that Justice Alito's questions were getting at. So what if on January 6th, the Capitol itself had not been breached? The protest is going on outside the Capitol.
The idea is to take
slap the seal. Police are, in megaphones saying disperse, disperse. They're too close to the Capitol. Their goal is to impede, stop the proceeding, stop the counting of votes. Does that violate the statute in your view under this impede language?
So I think that one relevant question would be whether we could satisfy the nexus requirement and show that actually the natural and probable effect of that conduct would be to have some effect on what's going on in the Capitol and in the mind run.
You can.
Yes. So if you're assuming that the same thing happened where Congress had to go into recess and couldn't hold the joint session after all because there was such a security risk, I think that probably would be chargeable if we had the intent evidence. Now, as I mentioned before, even with respect to the riot that happened, which was a much more serious breach, we don't have that evidence of intent for everyone. But if we had, for example, organizers where it was absolutely clear that they were the ringleaders who had intended to obstruct and undertook the action,
keep your eye fixed on that
intent and did so knowing it was wrongful, and especially if they went, I'm assuming you're saying they're in the unauthorized area right outside the Capitol, that is unlawful conduct committed with consciousness of wrongdoing if we have the proof of it.
Let's say that I am having a hard time seeing.
Also, the wizards, those are not wizards, those are druids, is what you're referring to. The wizard would be from like the bass player, like the hero would be a wizard type. So the Titan is a wizard.
First Amendment challenges. Can I be comfortable with the breadth?
The skeletons, the vampires, the zombies. The bone dragon here. Mummies. Those are necromancers. You have this guy right here, which is an ogre. That's a barbarian. You have the you'd have to show that the dwarf and the you'd still have to show Phoenix. That's going to be a sorceress. Even if you've got the Hydra and the Centaur here, and those two are going to be from the Warlock base player.
Broadly, so let's say that I think that Justice Alito's example of the protesters in the courtroom, it's let's say it's corrupt. It impedes the proceeding because we have to go off the bench and things are stopped. Let's say I think that that's covered by the word impedes, and there's the nexus and it's corruptly. Is it plausible to think Congress wrote a statute that would sweep that in?
Yes, I think that there are a lot of legitimate ways to try to voice your dissent if you disagree with what the court is doing. But
she doesn't get riled. She doesn't watch Q-Bot too much. She just watched it probably 4 or 5 times with me, just because it's been on and we spend time with each other. I have Twitch on all my main TVs. So in the master bedroom downstairs or here in my room, when she comes in and I'm working, she'll come through and watch. She doesn't like it. It's just like she'll be there while I'm watching it, and it's one of those times where she'll just monitor, if you will, what I'm watching and converse with me while I'm there. And if I plan it right, I can get her and Q-Bot in the same room.
Backdrop of a real world context. It was in the wake of Enron. There was document destruction. And, there was nothing, as far as I can tell, in the enactment history as it was recorded that suggests that Congress was thinking about
Sulfur?
obstruction more generally. They had this particular problem, and it was destruction of information that could have otherwise been used in an official proceeding. So can you just give us a little bit more as to why we shouldn't think of this as being a narrower set of circumstances to which this text relates?
Sure. And, I'd start by saying that we, of course, acknowledge that the immediate impetus for
Go for this fucker now.
Statute was to close the Enron loophole. It was a glaring loophole in the coverage of the obstruction laws that it wasn't a crime for you personally to destroy the document, and the government had to charge people for instead persuading other people to destroy documents. So that was front of mind for Congress, and Congress wanted to address it. It did address it with C1 and with 1519 separately. But I think the best way to look at what Congress was doing in light of that context is to consider the fact that Congress went further and enacted C2. The broader lesson Congress took away from Enron is that when you set out in advance to try to enumerate all the various ways that official proceedings can be obstructed, things will slip through the cracks. You can't
Let me
always
just ask you
foresee
this. Was C2 enacted at the same time as C1?
Yes, it was.
And so why couldn't the broadening relate to other ways in which one might prevent a proceeding from accessing information? So one is documents, records, and other objects, but the known unknown.
Yeah, blind my boys, but they still come in.
Could it be intangible, for example, that C2 is sort of getting at when one gets at physical objects? I guess I'm struggling with leaping from what's happening in one in the context in which it was actually enacted to all of obstruction in any form.
So I think the reason why we wouldn't suggest that the context could bear that narrower reading is because of the actual language that Congress used. If it was really just worried about other kinds of record-based, proceeding-based, evidence-based ways of obstructing, then there were easy templates to add that in as a residual clause to C1. There was no need to have this entirely separately numbered prohibition, and especially there was no need to use the well-recognized verb phrase obstructs, influences, or impedes, which was clearly drawn from these other omnibus clauses that sweep more broadly. So I think we think that it's perfectly consistent with the statutory history here to recognize that after Enron, what Congress thought is, we don't want novel ways that we aren't thinking about of obstructing a proceeding to not be a crime. We do want to cover the waterfront of obstructive conduct with the backstop of a corruptly mens rea, the limitation to an official proceeding, and so forth. And that's exactly what the words of the statute say.
Thank you.
Thank you, counsel. Rebuttal, Mr. Green.
Justice Sotomayor, a defendant who tips off a grand jury witness or tips off the targets of a search warrant is someone who is certainly attempting to impair the integrity or the availability of evidence and would be covered by C2. Just as somebody who creates a document and then that document is shown to counsel and counsel withdraws a mandamus petition has in fact created something that has caused an interference with an official proceeding. I heard my friend say twice in response to your questions, Justice Gorsuch and Justice Barrett, that C2 would cover peaceful protests.
All right. 2 heroes run around, 3 heroes run around.
The government could demonstrate that there was the adequate mens rea and a nexus. As to nexus, let's look at what 1512F says. For the purposes of this section, an official proceeding need not be pending or about to be instituted at the time of the offense. There is no nexus. Congress has written it out of the statute right there. If the J6 defendants came on January 5th and did all the kinds of things that they did, maybe one would hope, but if it had happened that way, it would still be a C2 violation. With respect to the corruptly mens rea, Justice Kavanaugh, you asked a question yesterday about the fact that mens rea as a break only works at trial because the government's allegations are taken as true at the motion to dismiss stage. And I think that's exactly right. And that's why it's not a break at all. Or if it's any kind of break, it's a break on a go-kart. It's a wooden stick. What it means is that people like Mr. Fisher have to sit and go to trial and seek to win on a Rule 29 motion because the government hasn't proved their mens rea. The same is true of First Amendment defenses if peaceful protesters are charged with C2. My friend referred to 1503 and 1505, other statutes within, and a number of the justices have pointed out that there are much lower penalties for significant crimes. I would point the court to 1752, which is civil disobedience in a restricted space, which is what Mr. Fisher is charged with. That's a misdemeanor. If you cause substantial bodily injury, that is a 10-year maximum penalty. The government wants to unleash a 20-year maximum penalty on potential peaceful protests. That in and of itself is a bad idea because it's going to chill protected activities. People are going to worry about the kinds of protests they engage in, even if they're peaceful, because the government has this weapon. Finally, I think we haven't touched very much on the breadth of influence because that's one of the words that's used.
Not sure why it's the person attacked.
And that would not only would it be peaceful protest, it could be advocacy.
Yo, brother, thank you so much for coming in, Notebook Dude. Have a great night. Get some rest.
In our briefs. Then finally, I would say to the court, let's not forget that civil proceedings are covered here. We would submit civil evidentiary proceedings, but civil proceedings. So the government is suggesting that the court should unleash a 20-year maximum obstruction statute on civil litigation in federal courts. I submit that we would submit that is a very serious tool to put in the hands of prosecutors. We urge that the court reverse the D.C. Circuit.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
Okay, wow. Let me pull out this real quick. While we're continuing to play just a little bit here, let's do presidential immunity. Supreme Court case hearing on presidential immunity. That one hasn't happened. What was the one that happened? It was the one where he said could use... No, I mean, presidential immunities happened. Supreme Court hearings, 2024. There's the Trump's ballot case, election, determination of future, and Supreme Court. Oral arguments, DOJ uses law charged in January 6th, the one we just saw. Whole bunch of where is Clarence Thomas? oral arguments here. Obstruction, Supreme Court, and charge. Man, these are all messed up. So, U.S. Supreme Court arguments former President Donald Trump's Colorado ballot eligibility. We already did one of those. I'll tell you what. So, we were on the January 6th. Let's listen to Midas Touch on January 6th. And then we can talk about it. January 6th, Trump calls. This is so. The problem is that I'm not a big fan of the Midas Mighty. I just know that they have commentary, but the problem is trying to find something that's good. Nah. All right. Let's see if we can finish this up. See if I can finish this up for you guys. There we go. All right, so it doesn't sound too good. It sounds really split down the middle. But we will have to see, I guess, huh? So my thing is, like, for the January 6th, what they're talking about is the different classes of... Let's see, we're here, they're there. Where are we trying to go? They're talking about the different classes that the law affects and how the law affects and what triggers first. And the idea that, you know, if you're going to... if we're going to charge this individual with, you know, these classes, then really you can just charge them with a misdemeanor, and it does pretty much the same thing. But they're talking about how the state is going, or it's the state, but it's the United States, but going for the maximum penalty when really it requires a lesser penalty. What they're talking about is something similar to New York, and how New York is able to go through and utilize this ability to charge Trump with a felony where you're dealing with multiple infractions of a law. But it's important to remember that the infractions that we're talking about here that are from the January 6th riot is something that was originally engineered to help deal with Enron, the 2001 fall of Enron. So that's important to remember. We're going to lose this one too. Yeah, there goes our boy. I mean, there's 6 of these guys. There's nothing we can do. So I'm not really sure what is, or let's see when. Yeah, he's down. He's down. Bloodlust. You're bloodlusting a dragon? Ugh. All right, I tell you what. There we go. Let's focus a little bit on what we have happening here. Discuss, and then head out for the night. That was a great run. I thought I was going to be able to beat the game, but or beat that setup, but doubt it, I guess. It's been rough. Like, when you get to the end on this map, like, you're always running around, especially on the expansion maps. You're running around, you're trying to get people to fit into boxes to be able to kind of like cover an area, but you never can, hit the bingo marks, if you will. So yeah, I don't know how the January 6th case is going to go. It really does seem to me that the January 6th case is, at least for these defendants, is not going to work. Now, what's important to note here is, and I don't know if y'all knew this or if y'all picked up on it, but this case is only affecting the defendants who are not Donald J. Trump, because, and here's the real big thing, right? They started getting into some of the Enron stuff, and they started getting into some of the documents. And the reason that it's only going to affect the defendants who are not Donald J. Trump is because they just broke into the Capitol. They ran around. They, performed lewd acts. They literally relieved themselves on desks. They burnt, flags and statues and things like that. But with that being said, those are the people who showed up and then went into the Capitol on January 6th. Trump was nowhere near there. He was miles away, and he was over at the White House whenever the attack on the Capitol took place. But what did happen was Trump had text messages and emails that were sent between people that were deleted. And that right there would fall in line with like the Enron scope, right? The idea of how Enron, for some of y'all that are too young, but some of us remember Enron. Enron was a massive financial crime that happened here in Houston at a massive energy company called Enron. And they basically ran out of money. Instead of declaring bankruptcy, they utilized all the money that they had from people's 401ks and pensions and retirement funds. And that's what they used to go through and do a lot of damage. So, unfortunately, there wasn't laws against that before, at least as many laws as there were before, but after that, clearly there were. So these were laws that were created to help protect us as a labor force, us as a society, once Enron had its issue that happened. And this is, kind of post 9/11, pre 9/11, just right around that time of 9/11. So with that being said, it covers that because Trump had emails and paper documents and text messages that were destroyed trying to obstruct justice. And that's why the statute will still apply to him. But the statute that doesn't potentially, and what seems to be very likely, won't be applied for these defendants that have already been found guilty of said crime. And yet again, what's interesting about this is that means that those judges would need to overturn these people's sentence and release them from prison, or forgive their sentencing if they have any time left, if that is what they were convicted on. What I find interesting about this is that, for years, people of color have been saying how the American criminal justice system has been corrupt. And it wasn't until we had a whole bunch of these white Proud Boys, or Donald Trump, who's facing criminal charges, and we finally hear from, if you will, a high-class white person. And what do they say? The first thing that comes out of their mouth: the criminal justice system is rigged. And I just, it's poetic justice, right? Like for a long time, if you just looked at the criminal justice system, you could tell that for-profit prisons was a bad idea. You could tell that it was a corrupt system. And when it was people of color, no one cared. But they did start to care, or the decision makers started to care, when it was white males, right? Like, that's the craziest thing to me, is that Donald Trump is, using so many legal footballs and fumbles to be able to halt the game, to be able to stop the clock, to be able to run it a little bit further without an actual play happening. It's honestly insane, and it only becomes of money, right? And that's the difference. That's the two-tier system that we have in this society, and that's what really frustrates me. What up, Gizmo Cat? Welcome in. We're actually about to be closing down the stream. We were listening to the Supreme Court case hearing while playing a little bit of Heroes to Gold, but we're listening to the Supreme Court case that came out this week, the oral arguments for the January 6th rioters and the charges that the rioters are being charged with. So really interesting. It seems like it's a hung jury so far for the Supreme Court justices. I'm pretty sure it's going to go by party lines, or you might get like a 5-4 split on that. But 5-4, and I think that the people are going to be overturned. I didn't hear too much concern about January 6th, and that's the problem with laws, right? That's what we go into. So we're talking earlier about some of this, but that's what we go into. There's another headline I think is crazy. What's the headline that you got, Gizmo Cat? What's crazy for you on this Saturday early morning, at least where I'm at in Texas? Yo, Dirt313 redeemed first, and it was well into the stream, but thank you so much, Dirt, for redeeming. You personally knew Donald J. Trump? Is that who we're talking about? You personally knew him, or you personally knew the gentleman who was in the trial who is suing and has made it all the way up to the Supreme Court? Two main guys here. So Trump is what I'm guessing, because I don't even remember what the gentleman's name is who's on trial, who's fought all the way up to the Supreme Court, but I would assume you're talking about Trump. No, the man who lit himself on fire outside the courthouse. Yo, you knew that guy? Oh my goodness, that guy. So we're on a whole different headline. You are correct. Yeah, that's insane. So did you find out anything a little bit more about that guy and why he did what he did? I mean, we can look that up real quick too while you're talking about it. We could definitely look that up and see. Guy sets self on fire in New York. We're going to do that. We're going to go to our screen share right here. All right. So this is what Gizmo Cat's talking about. Guy sets himself on fire in New York. Top stories. This was earlier today. Man sets self on fire at courthouse. New York Times got something out. Let's see what we can get. Hung out at least 5 times. He had a manifesto. I will say in the past couple of years, he became more of a conspiracy theorist. So he was a Trump supporter. Now, here's the thing, and I hate to, if it is too soon to laugh, I will probably laugh here, is what a, I'm not really sure what would cause you to set yourself on fire, but man, you've drank the Kool-Aid. How about no, Scotty? They have the paywall up. The paywall's up. Okay, let's do something else since New York Times wants to be like real stingy. Reuters. Like, don't they know clicks online equal money? New York, a man set himself on fire Friday outside the courthouse where Donald Trump's historic hush money trial was taking place. His jury selection wrapped up, but officials said he did not appear to have been targeting Trump. Yeah, he was. That's weird. Like, that's where you're at, Gizmo Cat. Like, that's insane. The man burned himself for several minutes in full view of television cameras that were set outside the courthouse where the first ever criminal trial of a U.S. president is being held. I mean, that's honestly insane. I mean, these people are genuinely insane. I do have a little bit of a story that can kind of go into this. Officials said the man, who is in his late 30s, survived and was in critical condition at a hospital. Witness said the man pulled pamphlets out of the backpack and threw them into the air before dousing himself with the liquid and setting himself on fire. One of those pamphlets, so that's the man right there? Wow. He looks like a villain or a heroine from a very in-depth story with that hair. 35 critical condition, set himself on fire. One of those pamphlets included reference to evil billionaires, but portions that were visible to the Reuters witness did not mention Trump. The funny thing is that, like, that's right. Like, to the evil billionaires, you mean Trump? Like, and I know Trump's not a billionaire, but I'm just saying, like, Trump claims he's a billionaire. His followers believe he's a billionaire, but the idea is like, you mean Trump? You mean like you're saying the evil billionaires, but like that guy? You mean the guy that you're backing? Like, you have Biden, who has like a couple $1 million in the bank account. Last year in 2023, he made $600,000, paid like $100,000 in taxes. Like, are you telling me that, you know, there's that guy and you're like, F him, but like Trump, who's like a multi-millionaire who has a following of corruption and all kinds of things. This guy, you're like, yeah, good stuff, man. Good stuff. Not the evil billionaire we're talking about. Fascist coup he was initially gonna protest at NYU, but changed course. It's weird seeing someone you know do this. You know, Gizmocac, real quick, I've got 2 stories for you, then I gotta go. One story for y'all is that I had a former coworker who was charged, tried, and convicted on sexual assault of a minor, and it's truly insane. When you look up the story behind that and you look up some of the core details and this and the other. But yes, it is truly insane, Gizmocat, to have someone who you know who's on TV or whose picture's on TV and they did something that you just couldn't believe. So I am fully aware of what you're talking about. Not specifically this instance. And that, but that feeling of looking and seeing them on TV, you're like, I know that guy. What up, Tim? Like, I know what you mean by that. And I felt that before. It's really insane. I even tried to talk to the gentleman in prison that I mentioned before. He was a former friend, but he decided he didn't want to until his appeals were over. Then his appeals were over, and he was, of course, found guilty every time. And then he's like, I guess I'll reach out to my friends. I'm like, fuck you. I'm not gonna talk to you at this point. Also, I was more interested in kind of finding out information about what was happening. Yeah, it's honestly insane. So today there was a gentleman who I normally talk to. I've actually talked about him on the show several times. And I work with him, and he's a really nice gentleman. He's an older gentleman. He's above 60 years old. Not 70, but above 60, and he's a real nice gentleman. But the thing is, he's mentally ill, and he is the person who told me about like the ancient sky dwellings and the ancient like ruins that have been around. And he's a big conspiracy theorist. I mean, y'all know the type, right? So there's that person, and the biggest thing about this was, I guess I was trying to get into a security system because as part of my job at work is tracking some of these like Amazon purchased security systems for water plants. And I'm going through and I'm checking, I can't remember what the password is. And I left it at the office because this guy called me in an emergency saying, I think someone stole my tools on my truck. So I'm like, well, I'm going to go to the facility real quick and I'll log in and you're there. So we're going to, be able to track down who stole the tools. So he, while I'm going through and basically like low budget hacking into this thing, he starts telling me like, hey, I remember, life flies by. I remember when I was, a kid and I was watching Looney Tunes and I counted to when I was going to be 30, and then that happened, and so on and so forth. Now, 20 years later, I'm, 58 or something like that. And ultimately, he was talking about Looney Tunes, and I said, you know what, I like the Jetsons, and I mentioned my family and how we like the Jetsons, and we also like Scooby-Doo, and then he brought the Jetsons and Flintstones into this, and he first brought up the Flintstones, then he brought in the Jetsons, but how he brought up the Flintstones was, hey, don't you think it's weird that the Flintstones, and so I'm sitting here, I'm just doing my thing, right? Like, I'm just like trying to hack in. No, that's not the password. That's not the password. And he's like, hey, isn't it weird that the Flintstones knew about like dishwashers and cars and like curtains and obvious things, right? And I'm sorry, what? So he's talking about, yeah, don't you think it's weird, right? Like that the Flintstones, who were cavemen, essentially, knew about dishwashers, cars, curtains, and several other things that they do. And they keep talking about the modern day, in a town of Bedrock and how they have towns and roads. And I was like, I mean, it's a cartoon. And then I continued with what I was doing. He said, man, this is the thing, right? The elites are controlling us and we are the Flintstones. I said, oh, it's a metaphor. And he goes, no, man, here's the thing. And I was like, oh God, there's more. So he was talking about how the actual cartoon, there was the Jetsons and the Flintstones that came together. And I was like, okay, cool. Like, I understand that. There was a crossover, if you will, between the two shows, which is great. It's a great episode or two, whatever it was. I think I remember it back in the day. I'll eventually get to it as I watch the Jetsons. But what's interesting is that he was saying that, they did that and they tell us these things. And I'm like, what do you mean they tell us things? And he's saying that basically this is almost like the story of what happened here on Earth. And I'm like, what are you fucking talking about? And he said, yeah, so like the billionaire elites are the Jetsons. They, during a prehistoric, extinction or nuclear holocaust, we are the people. We are the Flintstones, the ones that were left behind. We were able to survive, but we're, scrummaging through what was left on Earth. And that's why it's so chaotic. The super elites are the Jetsons. They're the ones that had the access to space and they left Earth and everything. I'm like, so are you under the impression, two things. Are you under the impression that there are elites in space that are richer than like Elon Musk, who can't get himself to space for more than like 20 minutes and that are like zooming around space in like, Jetson style vehicles? And then a second thing is, are you thinking that the Flintstones cartoon and the Jetsons cartoon are factual documentation in documentaries of time for us as human beings? And the answer was yes. So interesting. I mean, he didn't confirm yes and say yes, but he was saying no. I mean, they have to tell us these things and give us these signals. And I've never, when dealing with conspiracy theorists, I've never been able to understand why they say that. Like when you're talking about like the demonic, democratic, like Satanist cult, you have to tell people things so they are aware. Like, I'll be honest with you, like I don't know why that's a thing and how that's a thing, but they obviously haven't seen too many movies where the villain is always defeated because they divulge their plan. Haha, here's my plan and we're going to have it unfold and you guys are tied up and wait a second. No. You're untied and now you're undoing my whole plan that I shouldn't have told you about. Like that just doesn't happen. Like real evil people are never going to tell you that the plan exists and what the plan is. And they're probably going to throw a whole bunch of wrenches and engines to make sure that their plan is kicked off. Okay. and like it's a very child way of thinking. And I mean, it is true. Like they're mentally ill people. They're mentally ill people who believe in these conspiracy theories. And he started talking about, well, there's plenty of conspiracies that worked out to be fact. And I'm like, what conspiracy? Just give me one conspiracy. Said JFK assassination. I'm like, so it's important to note that is as much evidence as you have that is an interesting conundrum we have. Like, it's not fact. It's not been proven. The CIA, the government, everyone still who is an actual like law enforcement agent who looks into it will tell you that it's not a thing. So it's honestly insane. But nevertheless, it was an interesting experiment. I'm sorry for your friend who set himself on fire, Gizmo Cat. We have to have a moment of silence for them, and then we're going to end for the night. And I really appreciate you guys being here. But a moment of silence for the gentleman who was too mentally ill to not set himself on fire on behalf of Donald Trump. And there you go. I really appreciate everything that was going on here. And hopefully you guys have a fantastic evening. I'm going to be off for the next couple of days as I'm celebrating my daughter's birthday on Sunday. It's going to be a fantastic time. Hopefully y'all have a fantastic weekend. If I don't catch y'all in some of the streams, Gizmo Cat, I'll probably catch you in doubles. Chat Double, thank you so much for coming in. Thank you so much for the follow as well. Dirt313, and also there was an offline follow which was Loki2169. Thank you so much for the follow, Loki2169. Radical Maniac, I hope you come back soon. Radical Maniac was from a while ago. I am the Political Gamer. Please remember to follow here on Twitch if you guys are interested in more content, and also TikTok and YouTube. Remember to drop that subscription. I will check you guys next time. Have a fantastic evening. And God bless to each and every one of you. And I'll see you guys at the ballot box.
This podcast was brought to you by The Political Gamer, produced by The Political Gamer, edited by The Political Gamer, and associated with The Political Gamer. You can find our podcast recordings wherever you find your podcast, and remember to subscribe if you can, or drop us a follow us on Twitch, TikTok, YouTube, Instagram, Twitter, or X. We will be back next week for more news, laughs, and or TV.